that our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice formal applications. Issue number 2, my lords, arising from that.
Let us be discharged the directions of empanelment.
My lord, I am saying that we shall make a formal applications to discharge that order made by the Deputy Chief Justice. That's what we are indicating. My lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My lord, I have a lot of respect for all of you that have appeared before previously. But my lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoys special privileges. Number 2, my lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my lord, and it is important that this issue is speak for the wananchi and with a clear conscience. 2 things. My lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my lord, is this, the issue of bias. And this is bias by the honorable.
I think, Mr. Mugai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you...
Let me raise the other issue that again does not have to do with those spells. The last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my lord, there are about 4 matters, one of them in which I appear, and this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult, even for this bench, to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter, come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see, why I say this is important is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my lord, I urge the court to hold.
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done.
That is not
But
administrative.
if you have an issue with that, please don't make a generalized complaint.
My lord, this is not generalized. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My lord, sir, just to add on what my learned friend has submitted on,
with the permission of the presiding, I wish to say I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get appropriate, there should be no problem. We are all here to defend the Constitution of Kenya. So don't be worried. Don't be worried. Give us time. Let's take this thing step by step, and we will do the best we can as a bench.
Allow us to worry when we have grounds.
Senior Counsel Nute and Counsel Nebula, you know, when you argue the way Mr. Mgoy has argued, that court sat on Saturday, you are arguing on both sides of the court. You know that we work online. Most of you know that matters reach us anytime, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead the people outside there that court sat on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had in some way, let it not be an exchange between the court and yourself, because we are really very neutral party. Let us hear also from the other side.
We haven't E015 in the report. The deputy president is the second respondent, first respondent in fact. We haven't said our piece, and additional lawyer will be making submission. But my lord, do give us, this is a very weighty matter. This E015 in the report. The orders of your brother, Mr. Justice Mundo, were given at 4 p.m. where did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night to Friday? To give that, permit us to articulate these issues for the sake of the nation. We're not just dealing with the removal and the challenge to the removal of the deputy president. We are dealing about the president that will be set for the removal of deputy presidents in future and the removal of presidents in future.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This order